Most criminal attorneys won't tell you this, but cooperation is honestly the easiest thing for us to do on a case. When a client comes to us before making up a decision on cooperation, plea, trial, if your attorney from the jump is telling you, you've got to cooperate, you've got to come in, you've got to do all that, really be mindful of why they're telling you to do that. With cooperation, the attorney's work gets cut in half. Essentially, the client cannot look at the discovery, so the attorney does not need to be reviewing the discovery with the client. They can just do a cursory review. If you are cooperating in a lot of jurisdictions, the client can't have access to the discovery, so the client can't even look at it. The attorney also may be blowing all sorts of deadlines when it comes to motions and suppression hearings because the attorney is literally so focused on just scheduling the meetings and bringing the client in. And by coming in and by proffering, you are usually doing that under a proffer agreement that says that whatever statements you make were voluntary and you're waiving any sort of future right to having a suppression hearing on the basis that you are unrepresented, you did not know what was happening, or that your statements were somehow involuntary. So be very mindful if your lawyer is aggressively pushing you to come in and cooperate without really understanding what is going on. It's a big decision to make. It's a very dangerous decision to make, and you really need to understand the very big drawbacks that may exist if you were to come in and cooperate. Ultimately, you may not be able to go to trial because your attorney really pushes you into coming in and proffering in an attempt to get a 5K1.